Judge Henderson. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 19-3081, United States of America versus Rashaun Parks, also known as IV, Appellant. Mr. Smith for the Appellant, Ms. Heffernan for the Appellate.
Mr. Smith, good morning.
Good morning, Your Honor.
Please proceed.
Good morning, Your Honors. Jerry Smith for Rashaun Parks. I know this case, on the one hand, really all we're talking about here is what amounts to 1 year of supervised release, but I think the issue obviously is much larger. The real question is how the court is to use the sentencing guidelines at sentencing and when there should be a finding of prejudice when it incorrectly uses the guidelines, which unquestionably happened here. There's no question here that the court gave Mr. Parks an above guidelines term of supervised release. And there's also no question that he did this thinking that the term of supervised release that he did give was guidelines compliant, when in fact it wasn't guidelines compliant. And he was never aware that the lower actual guideline range applied.
Let me ask you, Mr. Smith, you said he did it knowing that it was an out of guidelines sentence. Do you take that from his statement that regardless of whether the 5 year to life applies, what are you basing that on? What exactly did he say?
Maybe I misspoke, Your Honor. He thought the guideline range for the supervised release period was 5 to life, and he gave what he thought was a guidelines compliant term of supervised release of 6 years. Of course, as it turns out, the guideline provision for Mr. Parks' term of supervised relief was exactly 5 years, no more, no less. So all the judge was authorized to give Mr. Parks for supervised release under the guidelines was 5 years, no more, no less. But he gave him 6 years, thinking that that was guidelines compliant. Your Honor,
well, that's my question: is what makes you why do you think he thought that? Because he also said whether or not this is applicable, I'm giving you 6 years.
That was in the pre-sentence report, which he adopted, and he also explicitly said on the record that he thought the term of supervised release was 5 years to life.
All right.
So I think that there's two different things going on, aren't there, counsel? It's that the statute, he thought that the statutory provision was that he had to give at least 5 years and he could give up to life, and that was also the guidelines range. But it turns out that the statutory range did not have a bottom of 5 years, right? The statutory range has a bottom of, is it 1 year?
No, Your Honor. The statutory range is 5 years to life, and we're not disputing that. So he could have legally given him up to life, and he could have legally come down all the way to 5 years. It's just that the guideline range was 5 years. For a Class C felony like this, usually the guideline range, I think, is 1 to 3 years. But there's another guideline provision, I forget, in 5D 1.2, that says when the mandatory minimum, the statutory mandatory minimum is such a number, the guidelines have to be at least that. And here the statutory mandatory minimum for supervised release was 5 years. So even though the guideline provision recommended a supervised release term of 1 to 3 years, that 5 year floor trumped. And that means that under the guidelines, the guideline range, it wasn't even a range, it was a point, was 5 years, no more, no less. That's what the guidelines called for. The statute permitted 5 years to life, and the judge mistakenly believed that the guidelines also called for 5 years to life. And thinking that he gave Mr. Parks 6 years, thinking it was guidelines compliant, but really the guidelines restricted him to 5 years, and he didn't know that. And that's really the problem here. He proceeded to sentencing thinking that the guideline range for the supervised release was 5 to life, when in fact it was only 5 years. And I think that would have made a difference. In fact, this is just a situation where the court uses an incorrect guideline range, not knowing he's doing that, and is not even aware of the correct guideline range, and ends up giving an above guideline sentence. And I think,
well, why couldn't we construe it to be his saying, whatever the range is, I'm going to vary from it? And
he could have done that, but we can't construe that because we don't know that he would have done that, because he never considered the correct guideline range. He was never made aware of it. The Supreme Court has made clear that having the correct guideline range is in fact the fundamental building block of any sentence a court constructs. Even if the court ends up deciding to give an above guideline sentence, he must still know the correct guideline sentence so that he can use that as a benchmark for gauging whatever variance he might apply. So the court could have varied from the 5-year range if he had chosen to do that, but to be able to make that determination, he needed to know what that range was. And here he never knew what that range was. He never even knew that it might exist. And that's the problem. A court has to have the correct guideline range before it can vary from anything. So here he never really was presented with a situation where he could vary from the guideline range, for the simple fact he just never was made aware of what that guideline range was. And
how do we construe his saying, regardless of whether it's 5 years or not, I'm giving 6?
Well, because when he said that, he was talking about the defense counsel had asked him. Defense counsel had made the argument that even under the statute, he could go lower than 5 years. And this is talking about the statute, not the guidelines. And the court, in response to that, said, well, counsel, even if I accepted your argument that the statute permitted me to go below 5 years, I would still give your guy 6 years. That's just because, for these reasons that I think he deserves 6 years, these non-guideline reasons. And that's where that comes in. I don't think that, but when he made that statement, he was still laboring under the misimpression that he could give Mr. Parks under the guidelines up to life. He very well may not have made that assertion had he known that the guidelines only permitted him to give Mr. Parks 5 years supervised release. So I think when he made that statement he made needs to be looked at in context. He made it laboring under the mistaken impression that he could, under the guidelines, give Mr. Parks up to life, when in fact the guidelines only permitted him to give him 5 years. If he had known that the guidelines only permitted him to give 5 years and he said, okay, well, I know that, but I'm deciding to vary from the guidelines, then it's fine. I wouldn't have any argument here. But my primary position is he still needs to know what the correct guideline range is, even if he gives what turns out to be an above guideline sentence.
Isn't your argument tantamount to saying that whenever the district court incorrectly calculates the guidelines, it's per se prejudicial, and under Strickland, isn't that essentially what you're arguing, even though that's not what the Supreme Court has said?
Well, I think that is sort of what I'm arguing, Your Honor, and I do think it's what the Supreme Court said. The Supreme Court has said in Molina-Martinez that, when a defendant can show that a court used an incorrect guideline range at sentencing, I can quote the language if the court will bear with me just a quick second. The error itself can and most often will be sufficient to show a reasonable probability of a different outcome, i.e. prejudice. And that's the base. That's the basis. And I think that's where we are. The court did say that there are unusual circumstances where that might not be the case. And the government feels that this is one of those unusual circumstances. the court then went on to elaborate what those unusual circumstances would be. That would be those situations where where the court made it clear that he would have given the same sentence even if he had used the correct guideline range. And the government thinks this falls into one of those exceptions, but it doesn't. The Molino-Martinez court was where the court used an incorrect range, and because of the incorrect range coincidentally overlapped with the correct range, he ended up giving a guidelines compliant sentence, even though he was not using an incorrect range. So I guess in that situation, it's possible to say that even if the court had known what the correct guideline range was, he still might have given the same sentence, because knowing the correct range wouldn't have necessarily given him any reason for giving a lesser sentence, since he never departed from the correct range to begin with. That's one situation where using an incorrect range wouldn't necessarily be prejudice.
But it was there.
No, in Molino-Martinez, it wasn't. The court there remanded the case for resentencing, even though, because the judge had used an incorrect guideline range, and even though the sentence he did give complied with the correct range, although I guess
that's what I'm saying. They did remand.
They did. They said you got to go back for resentencing, even there.
Even though it was compliant. Yeah.
Even though it was compliant with the correct range, they still said the fact that he used an incorrect range in and of itself was enough to remand the case for sentencing, even though the sentence was compliant with the correct range.
So, Mr. Smith, my question is about who decides. There's something sort of odd about us speculating on what the district judge intended or was thinking, or whether he was aware that he was going outside the range. You know, we often typically remand for the district judge to decide whether there was ineffective assistance of counsel. And here, I take it you're asking us to decide that. And I mean, I have some sympathy for that, because the district judges are swamped and going to be more so when we're back in business. But why should we decide this?
I think you can, if it's a clear-cut issue, decide if it's ineffective, is my understanding of the law. I know typically, like if it's a questionable issue, then it gets remanded. I don't think this is a questionable issue. I mean, the attorney forgot to inform the court of the correct guideline range. I think it's sort of I don't mean to come down on the attorney. It's probably a mistake I've made at some point, but still.
The probation office made the same mistake, right, in the PSR. But
the attorney's the advocate for his client. He needs to check the guidelines and make sure that the court is aware of the correct guidelines. And the attorney here made an honest mistake, but he did make a mistake. And I don't think there's any question that clearly he did make that mistake. And I think clearly there's a reasonable probability that had he not made that mistake, the outcome would have been different. I mean, here the judge gave Mr. Parks a 6-year term of supervised release when he believed that he could give him up to life. So I think there's definitely a reasonable probability that he would have only come down 1 year from what he did give, if he had known that's all the guidelines had allowed him to do. So I think there's a reasonable probability, but for counsel's failure to point out the correct guideline range, the judge would have come to 5 years. And I think that's sort of
you don't think we should take into consideration the fact that everybody missed this? I mean, it wasn't just that the judge was lulled into making a mistake by the defense counsel. As Judge Pillard pointed out, the probation officer missed it, the judge missed it. They all have an obligation to look at the guidelines and make sure they're being applied correctly.
That's true, Your Honor. But I think it can be couched. And I think the defense attorney, and, I'm speaking as a defense attorney, and I know we make mistakes, but I think the defense attorney has an obligation to do that. He can't pass the buck just because the probation officer and the judge didn't do it. That doesn't relieve him of his obligations to make sure that the guideline calculations are correct. And I know that other people made the mistake too, but that's still squarely on his shoulders. That's why we have a defense counsel there, to make sure that those kind of mistakes get corrected. And I know nobody else noticed it, but I mean, it's not like I'm some rocket scientist and I noticed it just by looking at the guidelines. It's not that difficult a thing to notice. I can't explain why other people didn't notice it, but I mean, it's right there in the guidelines. It's a pretty obvious issue.
Well, maybe the trial judge was lulled, in which case I would feel uncomfortable saying we're changing the sentence to 5 years instead of sending it back to let him.
Your Honor, I'm not asking you to change the sentence. I'm just asking you to remand the case for resentencing.
Okay.
And the court can be made aware of what the correct guideline provision is. And then if the court decides to give 6 years now that he's been properly informed, so be it. We have to live with it. I'm just asking you to remand the case for resentencing. All
right. I misunderstood Judge Pillard's question. Okay. Any more questions for Mr. Smith?
No.
All right. Ms. Heffernan.
Good morning. May it please the court. Patricia Heffernan on behalf of the United States. I just wanted to step back and just focus on the fact that given that this claim is, the sentencing error is before the court on ineffectiveness, appellant does need to show a reasonable probability of a different outcome. I agree with Judge Wilkins that a lot of this argument sounds as if appellant is pushing for per se, the court to find that per se when the district court has a guidelines calculation error, it's always going to be prejudicial. And that is not the standard under Strickland or under plain error when a case like this is before the court on plain error. The prejudice inquiry is the same and the burden is on appellant. And in this case, the district court—
Just a moment. So you do concede that there was deficient performance?
We did not push back against that. That's right. We're not arguing that
it's all about prejudice or not.
Yes, and we think that appellant cannot meet his burden of showing prejudice here, given the remarks that the district court made.
Just before we get into the weeds of the facts, do you agree? It sounded like you were saying that you agree that the prejudice prong of Strickland is essentially the same as the plain error prejudice analysis.
Yes, I think the court has said that in a case Williams at 358 Fed 3rd 956. And Williams is helpful in two respects. There at page 967, the court, referring to its prior opinion in Saro, discussed or noted Saro's comment about the natural analogy between those two different prejudice inquiries, and also cited to United States in Hall, where the court embarked on the same prejudice analysis with respect to both plain error and an ineffective assistance claim. So it's helpful in that respect, but it's also helpful in that the court there said that the burden remained squarely on a defendant to provide the court with a basis for suspecting that a reduction in his sentence is sufficiently likely to justify a remand. And here, appellant can't make that burden because of the remarks that the district court said. When the district court, in rejecting the argument, the statutory term of supervised release could be as low as 2. The court said at A132 in appellant's appendix that whether the 5 years is not, I do think it's required, but regardless of whether it would be required or not, I would come out at 6 years anyway. And it doesn't address the fact that the court didn't just say I'd come out at 6 years. The court gave very compelling reasons for why 6 is appropriate. It commented on the fact that the defendant had been acting as a pimp for 5 years. Every single 3 victims in this case, he was glorifying this lifestyle. His criminal conduct was his lifestyle and his career. The court considered the comments that the defendant's conduct as while he was working as a pimp, the conduct over the internet on Instagram, his advertising of these women, and said that it didn't appear to the court that the defendant thought that there was really anything wrong with what he was doing. And even at the point of the sentencing hearing, the court remarked that the defendant was not showing remorse. And the court was extremely concerned about the defendant returning to this lifestyle after what it termed a very moderate term of incarceration.
Just at a logically prior point, the district judge typically, if the district judge, it's within his authority to depart from the guidelines.
Yes.
Fully within his authority. But the district court also has an obligation to show an awareness of departure and to explain a departure. Isn't that correct?
That's correct.
And here, the district court didn't do that, right?
That's right.
And in fact, the district court noted on the record that neither party nor the pre-sentence report included any grounds for departing from the applicable guidelines range.
Dude, I just want to make sure we're here that this would be a variance rather than a departure. And I'm not trying to split hairs. I'm just trying to make sure I'm.
So yeah. Go ahead.
Yes, nobody had made that argument, but this case is not before the court on a preserved claim of guidelines error. Then we would be in a different situation, perhaps. Here, I think that the standard of review is important, and it drives the court's inquiry. I think here, given everything the court had to say about why it felt that 6 years in particular was appropriate, that appellant cannot show a reasonable probability of a different sentence. I think this record makes clear that if this court were to send this case back, that it would be futile, because the court would simply say, for the reasons I've articulated at great length at the sentencing hearing, I acknowledge that the applicable advisory term of supervised release is 5 years, and I'm going to vary to 6.
Well, so tell me why you think it makes a difference, the variance versus the departure.
Well, my understanding is that departures are specific departures, listed in the sentencing guidelines. So I just wanted to, I'm not, this isn't a 5.0. It's been quite a while since I've had a departure case, so I can't spout off the particular numbers of the provisions. But and variances are certainly looser. We're not trying to fit a square peg in a square hole that's identified by the guidelines. It's certainly, it's simply that the district court has discretion to vary from the recommended term of supervised release.
So here are two things that struck me, because at first when I was reading, I found your argument quite persuasive that, the district judge says, like, I want 6. And, when he's being pushed, and it was, as you acknowledged, is a different argument. It was a defense argument for going lower. And he says, I'm not going there. But he also explicitly talked about it in terms of the range. And he says, this is not the worst, and he said it warranted a low end of the guidelines. He talked about the defendant's criminal history as modest. And he rejected what the government was then pressing as, quote, already reflected in the guidelines range. So the notion that he would have, had he understood the guideline to be 5 years, nonetheless imposed 6, is, to me, that really raises a substantial question. And the other thing that I thought, in terms of this judge, he gave the 2 years imprisonment, even in the face of saying, frankly, the guideline here is a modest guideline, but he stuck to it. So I think you have reason to believe that this is a judge, at least in this case, who is really taking the guideline and the lodestar character of the guideline seriously, doesn't say, I'm going upward for this reason. And he could, on remand, do that. But to me, those facts make me confident that that is not what this judge was doing in this sentencing. That he wasn't saying, I know it's 5 years, or even if 5 years were the guideline range, I would think this person's conduct is more serious. The record does not support that narrative.
Now, see, that's interesting, Judge Pillard, because I have a different slant, and that affirms what you said earlier. That is, we shouldn't speculate on what the trial judge did or didn't do. It seems to me that he thought, well, I'll give him a taste of prison, the 2 years. But what I'm really worried about is when he gets back out on the street and starts again what he describes himself as a cut above the average pimp. I think a pimp is a pimp, period. And I think that's what, but again, you think one thing, I think another from what the district judge did. But that's I think the risk in our trying to predict what this judge will do.
Right. So I think I agree, we would remand for resentencing.
Yeah. I'd like to address just what you had to say with respect to the court's remarks. As I read the court's remarks, with respect to, I think the court had different things to say with respect to the term of incarceration and the term of supervised release. I read the court's remarks with respect to choosing, I think the guideline range was 18 to 24 months, and the court chose 22. And the court said that it was choosing 22 because he didn't think that that the defendant deserved the top, and it certainly also didn't deserve the bottom of the guideline range. And it explained that the appellant's criminal history wasn't totally too severe. I think he said it wasn't the worst in the world. And the court also discussed the fact that in some ways the defendant here, the appellant here, was not what one thinks of as the stereotypical pimp. There was no evidence that he was beating up these women, he said. And so I think that what the court was saying there was, this could have been worse. And so I'm not going to give him the top of the range with respect to incarceration. But it's also quite clear that it's going to be a problem when he's released. I've got concerns about deterring him. And so I think it's important to pull apart those remarks, because I think the remarks that Your Honor was referring to were really with respect to how much punishment the court thought appellant was warranted in this case, as opposed to the very different question of how much supervision is going to be required to make sure that his conduct is deterred and the public is protected. So I think those were two different discussions. And I don't think that the mitigating factors that the court referred to with respect to the term of incarceration bleed over and confuse the court's very clear remarks, I think, about what it thought the term of supervised release was warranted in this case. And so that's why when the court says, hey, even if I could go down to 2 or even if 5 isn't required, I still think 6 is the right number. And for the 6 compelling reasons that it lists on the same page of that transcript, which is A132. So I think under those circumstances, this court cannot say that there's a reasonable probability that the district court would have imposed a lower sentence. And I wanted to just push back on one argument appellant is making, which is this notion that, first of all, we shouldn't muddle the inquiry. The burden remains on appellant. So, but when appellant argues that only where the district court has acknowledged the possibility of the correct guideline, can this court find no prejudice, which isn't the inquiry anyway. But I would point out that if the court is acknowledging the correct guideline, you wouldn't be reaching a harmlessness analysis, because you'd have a court that says, well, I recognize this might be the correct guideline, and I would still reach the same result. Well, then you'd have alternate sentences, one of which is correct and no error in the first place. So I don't think that that's the proper legal framework to be viewing the prejudice lens through.
I'm sorry, what's not the proper legal framework? I just missed the distinction you're making.
Well, it's in appellant's reply brief, and I think I heard him argue here, only where the court has recognized the correct guideline can the court find the error harmless. first of all, we're not here on a harmless error analysis, so I wanted to correct that. It's appellant's burden to show a reasonable probability of a different outcome. But in framing the appellant's, that argument about prejudice and a prejudice inquiry, in that's really the factual scenario he's setting forth is a situation where there really is no error in the first place. This notion that if the district court acknowledged the correct guideline, then there might not be prejudice. Well, if the district court has acknowledged the correct guideline, then there really would be no error. And
but what about Melina? I'm sorry.
Go ahead.
What about Melina Martinez, where the district court used the wrong guideline, and even though it used the wrong guideline, it ended up giving a sentence that was within the correct guideline, and the Supreme Court nonetheless found prejudice under Strickland and sent it back. Here, the district court used the wrong guideline and imposed a sentence that was outside of the correct guideline, but you're saying that we shouldn't send it back because it was within the statutory range, and the district court recognized that I guess the district court said that, rejected an argument that it could go below what turned out to be the correct statutory range of 5 years. But I mean, isn't this at least kind of as a reasonable probability of a different outcome as Melina Martinez?
I don't think so, Your Honor. And here's why. In Melina Martinez, I'm going to just refer to it as Melina because I keep switching the names around. But in that case, the district court rejected the government's argument that Melina be sentenced at the top of the guideline range and imposed a sentence at the very bottom of the guideline range. And that gave rise to a reasonable inference that the district judge, it's reasonably probable the district judge intended to sentence Melina at the bottom of the guideline range, whatever the proper guideline range was. And so, and I think that's, that's a fairly obvious inference. And what the court did in Melina was simply reject the Fifth Circuit's categorical rule that a defendant can never show a reasonable probability of a different outcome based on the error alone. That's all Melina stands for. Here, so Melina didn't attempt to cabin situations in which the courts can find that there's no reasonable probability of a different outcome. And Melina recognizes, and all of the courts, Strickland and plain error prejudice inquiries recognize, that the court looks to the totality of the circumstances. So it's not just here, given the standard of review, it's not just the fact of the error, but is there a reasonable probability that if this court were to send this case back to the district judge would impose a different sentence? And the remarks that the judge made here make clear that there is no reasonable probability that it would have done that. But
the district judge also here gave what he thought was a sentence near the bottom edge of the guidelines for supervised release, right?
Correct.
So why doesn't that augur as to some reasonable probability that if he knew that the guidelines was actually 5 years, that, again, we don't know anything to a certainty, but why isn't there at least a reasonable probability that he would say, well, yeah, 5 years seems enough?
Because the court said that 6 was the number it wanted and that it would have imposed 6 even if the bottom had been 2. So we've got the court said, even if I could go down to 2, accepting appellant's argument, I'd still impose 6. And so that's why we know that additional information informs us that the district judge thought that in order to deter this guy, which was an incredibly concerning thing for the district judge, given all the circumstances and facts of the offense conduct here and the lack of remorse at sentencing, it felt that 6 years was what was going to be required, was the appropriate term of supervised release.
Although, Ms. Heffernan, also the district judge asked the prosecutor, he said, I haven't seen a case in which the supervised release term was this long. What makes this a case in which such a lengthy period is warranted? So the district judge is also expressing some discomfort about what he sees as a pretty robust period, and he makes his peace with it. But I mean, I know you're in an awkward position here because you're saying this is what the district judge meant, but also resisting a remand to this very district judge. And I guess part of the question
understand.
is what's wrong with that?
I mean, the government's view, it's important that the standards of review have meaning and that the prejudice inquiry isn't eroded. But I would say what the district court was pushing back on was the government's recommendation of a 10-year period of supervised release. Wasn't comfortable with that, didn't impose that. And but I would just point out also, the appellant pled guilty to one count of this violation, although he had been engaged in this conduct daily for 5, maybe even 10 years. So the district court is aware of that too, which is why it was concerned about deterrence. This is not a case where there was one transportation one time into the district. And so that, that informs the district court's decision. And that's why this defendant is very different from other defendants. And again, the inquiry here isn't, does the court have ultimate confidence about what the district court was thinking? The inquiry is there a reasonable probability if this court were to send the case back that there would be a different sentence imposed? And I think for all of the reasons and the facts of this case and the remarks that the district court made, including even if I could go down to 2, I'd impose 6, appellant can't meet that burden here.
Counsel, suppose, we were sympathetic to your argument, but we were also sympathetic to the argument made by appellant that we can't have a scenario where the district court can say kind of, even if this and even if that, I would still give you this sentence, because ultimately then we're going to create a situation where the guidelines are meaningless in having, we need to enforce the Supreme Court's admonition that the district court is always supposed to start with a correct guidelines calculation and then go from there in determining what the sentence can be. And certainly they can vary upward or downward, but then they have to explain that. In that if we simply affirm here, the argument is that we are going to erode that kind of fundamental premise of sentencing. Why shouldn't we be concerned about that? And how could we write an opinion here that wouldn't do that?
I think that would be a concern if this case were before the court and preserved error where the court was reviewing for harm. But here the standard of review is that the appellant has to show a reasonable probability of a different outcome. And so the court, I don't think the court needs to address, I don't think the court is eroding the import of the guidelines, and the court doesn't need to address that or accept that argument. Because of the standard of review, the inquiry is a specific and focused one. And it's whether had the district court known the correct term of supervised release, is there a reasonable probability that it would have imposed a different sentence? And the record here clearly, I think, says that no, it wouldn't have imposed a different sentence, and that a remand would be futile because on remand, given all the court's remarks about the seriousness of this offense, the time it went on, the fact that this was his lifestyle and his career, all the court would say on remand on this record is, for the reasons that I stated at the prior sentencing hearing, I acknowledge now the guideline range and I'm varying to 6 years. So under the facts of this case and the remarks that the court made, appellant can't meet his burden of showing a reasonable probability of a different outcome. And that's really the court's analysis. And that's the opinion that the court would write. I think the court would start with the starting point is, what is the burden and can it be, and has it been met here? And I think the answer to that is no.
Well, it may be that we might create a different type of remand and call it a ministerial remand. That is, for the district court to say, I was wrong, I made a error. It does not change my view.
Your Honor, I think some circuits have done that.
Right.
I'm not aware whether this circuit has. In the government's view,
I don't think we have.
Well, I don't know. In the government's view, that would be a pointless remand, but I think it's certainly open to the court to do that if that's. I don't have any case law that says that the court isn't authorized to do that.
Right.
But we do think that here, for all the reasons I've said, I think several times, that appellant has not and cannot meet his burden here.
All right. Mr. Smith, why don't you take 2 minutes for any response?
Thank you, Your Honor. I guess 2 points that I'd like to focus on. One is, the government counsel, Ms. Heffernan, has pointed out that the court said, I like the 6-year sentence, and here are my non-guideline reasons for why I think the 6-year sentence is appropriate. And they're arguing that this shows he wouldn't have deviated from that had he even known that there was the 5 years was all the guidelines allowed. But, just because the court gave non-guideline reasons for the sentence it imposed, that doesn't mean it would have not taken seriously compelling guidelines related reasons for giving a lesser sentence. I mean, the court knew as well as any of us that having the correct guideline range is the lodestar, the starting point for any sentence. So if he had known that 5 years was all the guidelines permitted, that would have given him a compelling reason for giving a sentence less than 6 years, a reason every bit as compelling as the reasons he picked, the non-guideline reasons he picked for giving a 6-year sentence. So it really is an open question as to what he would do at sentencing if the case were put back before him and he were then advised that a 5-year term of supervised release is all that the guidelines allow. And I have to show a reasonable probability that the outcome would have been different, but that's not, I don't even have to show that the attorney's deficient performance more likely than not resulted in the negative outcome. I've just got to show that it undermined confidence in the outcome. And I don't see how it can be said with any confidence here that if the court had been informed that the guidelines only allowed 5 years, he would have come down off that 6-year sentence, the 6-year term of supervised release he gave. And because of that, we have to remand the case to the district court, tell him that the guidelines only allow 5 years, and then let him factor that new information, this new compelling reason into his calculus. I guess the final point I'd like to make, and it's sort of picking up on something Judge Wilkins had said, the government's position appears to be that this court sort of insulated itself from review on the guidelines because it gave non-guidelines related reasons for the sentence, the above guideline sentence that it imposed. Courts almost always give non-guideline related reasons for the sentences they imposed. So in almost every single case, the government can make this argument, even in those cases where in every single case where the judge departs or unknowingly varies from the guidelines, he's not even aware of the guidelines. In every single one of those cases, when a judge unknowingly gives an above guideline sentence, there will always be evidence that the judge had non-guideline related reasons for the sentence he imposed. So if we allow the government's argument to stand that even when a judge unknowingly gives an above guideline sentence, that will be okay, just as long as he gives non-guidelines related reasons for that sentence. There's no point in the sentencing guidelines. And that's where I think we are. And that's another reason I think we need to remand this case to the district court to have him look at it now, being fully informed. Thank you.
All right. No questions for Mr. Smith? All right, Mr. Smith, you were appointed by the court and you've done really an outstanding job. These guidelines are complicated. It's like a minuet, and I know on my appraisal, I'm going to say that I put you at the top of the list for representation in these cases, certainly. And Ms. Heffernan, it is always a pleasure to see you. So thank you.
Thank you for your time, Your Honors.
Case number 15-1056, Hearth Patio and Barbecue Association Petitioner versus Environmental Protection Agency. Mr. Chung for the petitioner, Ms. Bat for the respondents.
Mr. Chung, good morning.
Good morning. Thank you, Judge Henderson, and may it please the court. For nearly 30 years, EPA's air emission standards for residential wood heaters accounted for the widely shared expectation that emission test results will vary, sometimes significantly, when a single heater is tested repeatedly in one lab and when that heater is tested in multiple labs. EPA included several substantive protections in the original 1988 standards to avoid putting the burden of this variability entirely on manufacturers, which were almost all small businesses. In 2015, EPA arbitrarily removed those protections, and in doing so, violated basic principles of administrative law. Because the 2015 audit provisions are arbitrary and capricious, this court should set them aside. I want to begin with the threshold question of ripeness. The issues in this case ripen for review upon the rule's promulgation. This court has repeatedly recognized that arbitrary and capricious challenges present purely legal questions. This case involves the purely legal questions of whether EPA adequately explained its reversal of longstanding regulatory protections and whether EPA offered a reasoned basis for the 2015 audit provisions. These are fit for review now. Yes, sorry, Judge.
There are two kind of interlocking issues that I see. One is ripeness, and the fact that even though these standards have been promulgated for over 5 years, we have no indication that they've ever been implemented in the unlawful way that you allege. And secondly, we require as part of our rules, the federal rules of appellate procedure and our circuit rules, that standing be demonstrated in the opening brief and in the docketing statement. And the only statement we have in the docketing statement and in your brief really is that your client, the association, represents members who are affected by the rule, but we have no listing of who those members are, no affidavit or declaration. And so even if we believe that the rule is problematic, we have kind of like no indication of who's injured and no indication of that an injury is going to happen. And the EPA says, well, there's kind of like this review or hearing procedure that might remedy any injury if it were to ever happen. So why doesn't all of that augur towards dismissing this petition?
So, Judge Wilkins, regarding the first point in terms of whether EPA has implemented the audit provision in the last 5 years, well, in responding and attempting to respond to Hearth, Patio, and Barbecue Association's concerns, EPA's response was effectively, we don't plan to audit during the first 5 years, so there's no need to worry about that. But if that were good enough, then EPA would always be able to dodge review in these sorts of cases, because remember, the Clean Air Act requires that challenges to nationally applicable rules such as this one have to be brought within 60 days. EPA could just sit on the rule temporarily and refuse to implement it, and it could always evade review. To your second point, and the question about the injury, well, the injury is self-evident from the record, Your Honor. The petitioner's members are the directly regulated entities, and this court has always...
The members are, I mean, are they not retailers? Are they actually manufacturers who are subject to these, or are they retailers of Hearth, Patio, and Barbecue materials?
So the petitioner's members include both manufacturers and retailers. This case is being brought on behalf of the manufacturers.
And I think the question here that Judge Wilkins is asking is, how do we know that? Is there anything in the record, any evidentiary material to meet your threshold burden to establish standing?
So the materials in the record come from the comments and that are in the joint appendix. On behalf of the manufacturers, the Hearth, Patio, Barbecue Association commented on the impropriety of the audit test provisions and how they fail to account for variability. And that's causing us injury now because our members have to spend tens, if not hundreds of thousands of dollars to develop products that not only meet
Before you go on to describe the injury, we're really at a very threshold question, or Judge Wilkins raised a threshold question about where in the record are the manufacturer members identified and their role in making the kinds of room heaters and central heaters that are subject to this rule.
So in Joint Appendix 227 through Joint Appendix 233, we talk about the concerns that our manufacturers have with audit testing. And
right, but we understand that the nature of the concerns. The question is the identity of your members. No members are named there. Am I right?
Well, if the question is whether we specifically call out companies by name, then
or have identified, we are, our members include people who manufacture what?
Right. So in our opening brief, in the statement of standing, I believe it includes, and bear with me for a second. I believe it indicates that our members are the manufacturers who are directly impacted by both the standards and the audit testing provisions. Bear with me for a second. So that's on page 21. Our members include the companies that manufacture residential wood heating appliances that are regulated by this rule. And as I was initially indicating, the manufacturers have to spend money not to just meet the standards once, but they have to try to get far enough below the limit that they have some chance of surviving an audit. And on that point, it's important to emphasize that you can't really divorce the substantive standards themselves from the audit provisions for standing purposes. Our members have to design in light of both of those provisions now. And to be sure, the provisions like audit testing requirements are substantive requirements. In cases like Appalachian Power 208 F3rd at 1027, this court has recognized that things like test methods and the frequency of testing for compliance are substantive requirements and that they impose obligations and duties directly on regulated entities. They can also affect the stringency of the limit.
Yeah, that's an interesting question and something I was wondering about in reading the briefing. I think you just said you can't really divorce the substantive requirements from the audit, substantive standard from the audit requirement, but you're not challenging the substantive standard.
So if I may put a finer point on that, you can't really divorce the emission limits, the particulate matter limits from the audit testing requirements. Both are substantive in this court's view, according to prior Clean Air Act precedents. And so, yes, to your question, Judge Pillard, we are not challenging whether the particulate matter limits themselves are achievable on a one-off basis. But what we are challenging is the ability to audit and require manufacturers to meet those time and time again without any adjustment for variability during the audit testing. That's what we're challenging here. So regarding the merits, the challenged audit provisions are arbitrary and capricious for two reasons. First, EPA failed to explain why it was changing its longstanding positions on audit testing and variability, and it cannot now rely on belated justifications. Secondly, the justifications EPA now gives fall short because EPA did not actually build margins of variability into the standard, but even if it had tried, the claimed margins lack record support. So the Supreme Court recently reinforced in Regents that it is a foundational principle of administrative law that judicial review of agency action is limited to the grounds the agency invoked when it took the action. When EPA finalized the 2015 audit provisions, it never acknowledged, much less justified, why it was removing specific protections from the prior rules that accounted for variability. These failures are evident in EPA's brief. In trying to show it had good reasons for changing the audit rules on pages 34 and 35, there isn't a single citation from EPA's rule, the preamble, or the response to comments. The reason is EPA did not explain in 2015 why it was no longer prohibiting audits on an interlaboratory basis, nor did it justify deleting the regulatory text that provided for adjustments to the emission limit during audits. What
well,
EPA
it does refer to, it says a reason that the different laboratories might produce different results is about financial incentives. So one way of understanding what EPA did here was it assumed there was variability, but when it circled back and was actually confronted with the 2010 Kirkheap-Ferguson material that Hearth, Patio, and Barbecue Association says is the substantiation of its concern. When the EPA looked at that study, it said, oh, actually, we don't think there is as much, we don't think this does substantiate the point. So variability was overblown. And another reason for variability was this conflict of interest. So we're gonna put in place conflict of interest protection, and we're gonna go forward and assume that just as we've tested to set the initial emissions limit, we're gonna assume that testing works for auditing. And that's, I mean, that all of that is in the record and is an explanation for the new rule going forward.
So to the first question about the conflict of interest, the discussion on its face is speculative. Essentially, EPA is trying to come up with reasons why test results might vary from lab to lab, but the explanation doesn't really hold up. Again, remember, the labs that conduct this testing have to pass EPA proficiency requirements. And so the explanation doesn't really make sense if EPA is calling into question the proficiency of its labs that are accredited to conduct the testing. There are ways to address that. But speculating as to whether there are financial incentives to cook the books just simply doesn't hold up. But more importantly, Judge Pillard, you indicated that EPA is essentially acknowledging or assuming that there is variability. And that's a really key point here, because the absolute most that the record studies show is that EPA is disputing the claims about the magnitude of variability, but that's very different from saying that there is no variability. Now, remember, they finalized an audit provision that effectively says EPA is not going to consider variability at all during audit testing. If all of the record evidence uniformly confirms that variability exists, it is not reasonable to finalize an audit provision that ignores it. And the practical effect of this is obvious. The way the rules are set up, any exceedance of the emission limit results in revocation. Even if, for example, a wood stove is tested and it comes back during an audit at 2.1 grams per hour, that's above the 2.0 gram per hour stove, and that manufacturer loses its certification. How can that be a reasonable result when all of the record evidence shows that there is variability, and EPA is not disputing that? All it's saying is maybe it's not as great as the Kirkheap-Ferguson study says it is. But again, that's very different from saying there's no variability. In addition,
Can I ask a question though? If you gave the example, if a test comes back at 2.1, isn't there a process for the manufacturer to challenge that, and it's not like an automatic decertification?
So great question, Judge Wilkins. Here's the recourse that a manufacturer would have. It would have the ability to test 2 additional units, and if the average of the 3 tests comes in below 2.0, then that would be considered a pass. Or it can test 4 additional units and hope that all 4 tests come below 2.0. But again, the plain language of the reg says that an exceedance, if there's an exceedance of the emission limit, EPA will start the revocation proceedings. So EPA's belated justification that the audit provisions, the fact that they no longer account for variability is no big deal because you'll have the ability to appeal. It's questionable how EPA could indicate that it could comply with its regulations if it somehow excused variability during the course of an individual audit. The rule says what it says, which is an exceedance means revocation. So it belies EPA's defense that maybe somewhere down the road, it will take additional evidence of variability into account. That flies in the face of the regulation, which is why their ripeness defense doesn't really hold up.
Can you at some point before this argument concludes identify someplace in the record before us where Hpva identifies its members or identifies a manufacturer who is a member of the association?
Yes, I will do that during Ms. Bach's presentation.
And Mr. Chung,
Yes.
there's no record of variability with respect to audits or testing of central heaters in this record.
Yes, that is correct. And that was my follow-up point to the fact that EPA is bickering about the magnitude of variability. You're correct, Judge Pillard. All of what we've been talking about and all of the evidence in the record goes to wood stoves. So for 2 of the 3 appliance categories at here, what we have is a complete failure to analyze the issue altogether. There's no data on variability for furnace testing or hydronic heater testing, which is fatal to the claim that it built a margin.
Cut the other way in the sense that there is no data that variability is a problem when testing the central heaters, which are more sophisticated equipment. Their oxygen intake is more regulated. The fuel that's used to burn in them tends to be more standardized because it's not your little, common room wood stove. It's a furnace.
Respectfully, Your Honor, I think it actually cuts the opposite direction. So 2 things jump out. The first thing to keep in mind is that there are multiple test methods in play here. For each category of appliance, there's both a particular matter measurement method and an operation and fueling protocol method. So there's variability in the particulate matter measurement method, which is true across all 3 appliance categories. But with respect to the appliance fueling and protocol methods, I think it's important to distinguish between the engineering that goes into the firebox and the complexity of the operation and fueling protocol. So the firebox for the central heaters is bigger, which, if anything, introduces additional variability. So 2 things. 1, the operation and fueling protocols are more complicated on the central heater side. On top of that, the more wood you load in, the more variability you could introduce because how the fuel load settles as it burns, how it collapses, all of those are potential sources of variability. So the bigger the firebox, common sense suggests.
But we don't have any evidence of that.
Well,
There's no evidence of that you've put in and comments. There's no evidence in the record on that whatsoever.
So the lone comment, and this comes out in our reply brief, the lone data point on variability indicated that variability for 1 hydronic heater was very large. And that site is in our reply brief. That is the only thing that is actually a data point showing that there's, what happens when you test a hydronic heater more than once. But, keep in mind, Your Honor, EPA wasn't regulating on a blank slate in 2015. It had been regulating wood stoves for almost 30 years. There was no reason for it to believe that when you test a central heater, there wasn't going to be variability or that it would magically disappear. It's incumbent on EPA to prove what has changed between 1988 and 2015, when for almost 30 years, there was a longstanding recognition that variability is a problem. And therefore, it built in an outright prohibition on doing interlab audits, for example.
So it's your position that the variability of the audit testing for central heaters really follows from your position on the variability of the audit testing on the room heaters.
That's in part true, but also take it from EPA itself. Look at the test methods in the rule, Joint Appendix 63 and 75. Section 15 of the 2 hydronic heater methods on its face say that there's too much variability to be able to determine the repeatability or the reproducibility of this method. That statement in the test method itself is fatal to EPA's claim that it built in margins of variability.
Remind me which page you're reading from.
Joint Appendix 63 and 75. This is in the rule itself. Section 15 is entitled Precision and Bias. And the statement is identical in both test methods. It's two different test methods for hydronic heaters because there are multiple types of hydronic heaters, but the sentence is one and the same. It's not possible to specify the precision of the procedure in this method because the appliance operating and fueling protocols and the appliances themselves produce variable amounts of emissions and cannot be used to determine reproducibility or repeatability of this measurement method.
This is not talking about particulate matter.
Correct. This is the operating and fueling protocol test method. The particulate matter measurement method is 5G or 5H, which is a different set of problems, right?
And so, isn't the, you said that there's variability in the testing method, but isn't one of the changes also that EPA made was to throw out a number of testing method options precisely in order to have more consistency?
No, I would dispute that, Judge Pillard. EPA gave options for using different test methods for two reasons. One is there within each appliance category, there are different subcategories of appliances. So in subpart AAA, for example, you have a test method for the stick burning wood heaters, and then you have a separate test method for the pellet burning wood heaters. For hydronic heaters, you have a default test method for hydronic heaters. Then you have a different test method for ones that have partial thermal storage, a third test method for ones that have full thermal storage, and yet a fourth test method for cordwood heaters.
Back up. My question was much simpler, which is that for the same heater, it was my understanding, and maybe this is a better question for EPA, but it was my understanding that under the 1988 rule, that the laboratory could choose from among a range of different methods for the same device in testing device.
I'm sorry, I misheard you.
No longer do that, right?
So you're referring to the different options available for the particulate matter measurement method, which are 5G versus 5H.
Because you said, just as a matter of advocacy, I'm finding this a little bit challenging. You've said they've done nothing to acknowledge variability. And I mean, it just seems like that's an overstatement. They have acknowledged it. They've improved cordwood testing. They've identified conflict of interest and addressed it. They've addressed the Kirkheap-Ferguson study in its substance. They've, in the audit provision, they've acknowledged variability and allowed rebuttal of the evidence on which they've relied. And they've chosen more, and they changed the substantive standard from the proposed rule to the final rule to create a buffer, to require less exacting performance on the part of the stove. So to say they've done nothing, I'm just having trouble understanding your response to what they did do.
So the rules no longer protect manufacturers against the risk of variability, and that's because they now allow for audit testing at any lab of EPA's choosing, and there's no longer provisions that restrict or that provide for adjustments to the emissions limit to account for interlab variability. EPA scrubbed those requirements out, which is to say that the audit testing provisions effectively assume that variability is zero. Because
what
again,
about the building in of buffer at the front end in the substantive standard?
So that's
acknowledgement.
So that is the margin defense that EPA is now raising. I think the margin defense suffers from numerous flaws. First of all, it is post hoc. Certainly with respect to furnaces, there's nothing in the record that resembles a statement that they built in a cushion into the margins for furnaces. And the reason is obvious. The brief candidly acknowledges that in 2015, EPA didn't even have data points showing that the number was achievable. If there's no data indicating that the limit itself is achievable, how is it possible that EPA could have built a margin or a cushion into the standards? The second point is the margins are set so low that there's very little room here for error here. You know, how is a manufacturer supposed to build in a margin to an ever shrinking number? There's no, you can't really slice the bologna any thinner. Thirdly, when EPA claims that it builds in margins, it refers to the same preamble statements over and over, which are at Joint Appendix 15 and 16. Those statements are vague at best. They cannot fairly be stated or construed as stating that EPA built specific margins into the to the emission limits, because EPA never actually made findings about variability and did not analyze the expected amount of variability. All those statements say is, if we assume that commenters are correct that variability is a certain amount, that's not going to be a problem for the cleanest appliances. But paraphrasing what commenters claim is very different from making a finding on variability. And again, we have to take a step back and look at this against the regulatory backdrop of nearly 30 years. EPA knew variability was such a problem in 1988 that it dealt with it in multiple ways. It, first of all, differentiated between intra-lab variability and inter-lab variability. For intra-lab, it very explicitly said, we are finding and building in a 1.0 gram per hour margin. Manufacturers, you are on notice. You better take that into account in designing your products. Don't design something that hits 7.5. You better come in under, because you might not be able to survive an audit. On inter-lab variability, EPA committed to collecting data, doing a statistically sound analysis, putting those findings out for notice and comment, which it never did over the years. But because it never did that, there was an outright prohibition on doing any inter-lab audit testing for 27 years. That all gets swept under the rug effectively now, because again, there wasn't even a recognition in any of the joint appendix sites that EPA was changing the audit rules in a way that would lift the ability to do inter-lab audit testing, much less an explanation as to how it analyzed inter-lab variability. You have to view that against the lens of, there was this long-standing commitment that it was supposed to study and do a fulsome analysis, and it never did that. EPA never fulfilled its promise to meaningfully analyze this issue in 1988. Fast forward to 2015, they throw a bunch of data points out there, but they never really explain how they got to the claimed margins that they're now relying on. They never explain why, what particular data points they're emphasizing over others. A lot of this comes out in EPA's brief, but again, our view is that that's post hoc and cannot be considered under cases like Regents and Chenery. But again, the claimed margins, those statements on their face don't even make sense. If anything, EPA is implicitly conceding that there's no record support for the claimed margins, because all they're doing is accepting at face value commenters' claim that variability is, quote, no better than 1 gram per hour. By approaching the issue in that way, EPA is all but admitting it doesn't really know what the true amount is, or much worse, that variability can be significantly higher than 1 gram per hour. If it's higher than 1 gram per hour, that means that the cleanest stoves at the time, which EPA was holding out to be the best of the best, i.e. the 1 gram per hour stoves, would still fail an audit. So the margin defense makes absolutely no sense. And then the final point, I'm way over my time, but the final point is, again, for central heaters, remember, there's no data whatsoever for EPA to base a variability finding on. So how can they possibly have built a margin into the standard when there's no data indicating achievability for the furnace standards, and there's nothing, no data points on which to build a margin for the hydronic heaters? And on top of that, the test methods say we can't really measure the variability here.
Okay, you haven't objected to the achievability of the standards.
So again, this is where, achievability of a standard once is very different from achievability of the standard during subsequent audits.
Is it?
Repeatedly.
Is it?
Yes, Your Honor, in cases like Appalachian Power, again, the frequency at which you measure compliance changes the stringency of the standard, because meeting a number one time is much easier than meeting that number repeatedly, especially when you know that there is inherent variability baked into this, right? EPA is never saying that a 1.0 gram per hour stove is going to hit 1.0 every single time, whether it's tested in one lab or whether it's tested in multiple labs. Quite the opposite. All of EPA's data points and record sites all acknowledge that there's variability. It's just trying to dispute the magnitude of the variability. That's very different from saying there is no variability at all.
All right. All right. Are there any more questions? We'll give you some time in response, Mr. Chung.
Thank you, Judge Henderson.
Yeah, if there aren't, we'll hear from the EPA. Ms. Bott.
Thank you, Your Honors. Good morning, and may it please the Court, Simi Bhatt for EPA. Your Honors, during rulemaking, Hpva advocated for a buffer to be incorporated into the standards because even the best performing heaters cannot attain exactly the same test results every time. EPA listed and set standards not at the lowest levels achieved, but at levels about twice as high. Those same margins of variability are incorporated into the audit test because it is exactly the same test as what manufacturers must pass originally to certify that their devices comply with the standards. What's more, during the audit process, manufacturers can rebut a failed audit test with any relevant evidence, including on variability. Hpva's challenge to the audit provisions should be rejected for 3 reasons. 1, the standards themselves accommodate variability. 2, EPA's technical conclusions on variability are reasonable. And 3, EPA will consider evidence on variability should manufacturers present it in an audit hearing.
When you say EPA's technical conclusions on variability are reasonable, what are you referring to? I'm sorry. What are you referring to? What is EPA's technical conclusion and where is it documented?
Yes, Your Honor. EPA's technical conclusion is that the margins of variability built into the standards are sufficient. They account for repeatability, reproducibility, reliability, precision. I think that you can find exactly those words on pages JA 287 and JA 297, which is in the response to comments. So,
and the current position is that the margins are adequate?
Yes, that is EPA's position. And as I said, those conclusions are based on EPA's evaluation of all of the technical data submitted, not just Hpva's study, not just Kirkhead-Ferguson, but also the analyses that were submitted by another manufacturer, Woodstock Soapstone, as well as a study that EPA sponsored at the Brookhaven National Lab. Those are specific pieces of technical evidence that EPA weighed. For example, in Brookhaven, EPA was looking at the variability within one lab and found that variability was much less than Hpva estimates and also less than is incorporated into the standards. And then on interlaboratory variability, the Woodstock Soapstone study shows that variability is, again, much less than Hpva argues and also less than is incorporated into the standards. So for those reasons, EPA concluded that the margins in the standards are sufficient.
How can you say it's less than what's incorporated in the standard when the variability was over 1.0 grams?
Well, Your Honor, the variability was not over 1.0 grams in the Woodstock Soapstone study. Those heaters regularly came in under 2 grams per hour. And some of them, yes, came in around 1 gram per hour, but slightly over that.
Maybe I'm thinking of the Puget Sound Clean Air Agency that the EPA relied on. It had imprecision rates higher than 1.0, right?
Yes, Your Honor. Puget Sound didn't conduct its own study, but it analyzed Hpva's data. So yes, Puget Sound did conclude looking at Hpva's data that variability could be 1.0, could be higher than 1.0. And that's because, as Puget Sound identified, there are several flaws in Hpva's study, and Hpva's data is not applicable to the new heaters that are governed by these new standards. So there.
Go ahead. I'm sorry, I didn't mean to interrupt you.
I think as Puget Sound explained, Hpva's data is based on these old heaters, which were much higher emitting. They had much higher grams per hour of particulate matter emissions. So their variability as expressed in grams per hour is also higher. When you're looking at these new heaters with lower emissions, their variability in terms of grams per hour is also lower. That's why I think the percentage variability is more informative. And when you're looking at that percentage variability, that is adequately accounted for by these standards. And it takes into account that the grams per hour variability are just going to be less for these new heaters because their emissions are less in grams per hour as well.
So
what about, oh, I'm sorry, go ahead, Judge Pillard.
I was just going to follow up on the Woodstock Soapstone study talks about minimal inter-laboratory variability, but none of the studies, either on Hearth, Patio, and Barbecue Association's part nor on the EPA's part, address the central heaters. And I guess it's really a burden question. What's your position on that? Because they say, aha, you have nothing. They want numbers, they want tests, they want you to run something that shows here are the laboratories that test these boilers, and here's how they come back and audit, and here's the accuracy numbers. And we don't have anything like that. And I guess the question is, why isn't that fatal to this rule?
Your Honor, yes, it is a burden question. It is petitioner's burden to show that this would be a concern. But more than that, what we have in the record is a statement by petitioners that they expected variability for hydronic heaters, which are a type of central heater, to be similar as precision for wood stoves, those room heaters. So not only is there just a lack of data presented by petitioners on this issue, they in fact agree that variability would be
That seems like a little bit of a stretch. I mean, that's the PowerPoint you're talking about?
Yes.
And they're talking about it in the context of, and I don't know if the record reflects where that was presented, but they're saying, we think there's a variability problem, and we don't have reason to think that there isn't a variability problem with the central heaters as well, which is quite a bit different from saying, we think that the precise problem or lack thereof that we think is manifest in the room heaters is to the exact same extent manifest in the central boilers.
Well, Your Honor, the exact words that they used is precision is likely to be similar to the precision for the wood stove test methods. So I agree that the context is precision is a concern for both of these different types of devices, the room heaters and the central heaters, but they did say precision is likely to be similar. And as I said, there is really no data showing that precision is so much more of a concern for central heaters, nor does that really make sense. I mean, these are the same category of sources in the end. These are wood heaters, they burn wood, the sampling method, the particulate matter sampling method is the same. So it is really petitioner's burden to show here in this context that there would be some sort of greater concern for the central heaters than there would be for the room heaters. I think, Your Honor, Judge Pillard had pointed this out before, but EPA didn't just account for variability when setting the rates of the standards. It also accounted for variability by improving the test methods within the standards. And yes, I am referring to the test methods for sampling particulate matter emissions. As petitioner has acknowledged here, there is one test method here. It is by petitioner's own calculations, 10 times more precise than one of the other methods that was available under the previous rule. And the conflict of interest provision is another way that EPA has decreased the likelihood of variability in the different labs. I think petitioner has said at argument today that it's just speculation that conflict of interest was a problem. But if you look at the Woodstock soapstone study, in that study, you'll see an analysis that it's so unlikely under the old rules where there was no conflict of interest prohibition that the original certifying lab was actually using the same test method as the other labs that didn't have a financial interest in the outcome of the certification tests. It was less than a 1% probability that these tests are being conducted in the same way, which of course would yield greater variability.
Can you just list for us the ways that you believe that the record reflects that the EPA responded to this issue? You mentioned conflict of interest. You mentioned narrowed specification of which test methods could be used. You mentioned the higher initial emission limit. You mentioned the ability in an audit hearing to rebut, including with evidence of variability. Are there other things you think that we should be considering? There's something I had about the improved cordwood tests, about responding to Kirkheap-Ferguson, but I don't know if you see those as separate.
Your Honor, I think the four items that you mentioned are the critical factors. And I'd just like to elaborate a little on that last point, the audit hearing. I think Petitioner has neglected to explain the full context of the audit hearing. It's not just that manufacturers can test 2 or 4 devices and those devices would have to meet certain levels and then they would end up passing. That's not the case. The audit hearing provision allows the presentation of any relevant evidence. So manufacturers can present test results from their research and development phase, other test results they have. The manufacturers are required to do their own, internal auditing. There's a third-party certification process. They're supposed to look at their information every year. So there's a lot of data that they should have at their disposal that they can marshal in this audit hearing. Now, EPA has provided options, the 2 and 4 devices that petitioners have mentioned, which will automatically rebut a failed audit test. But if they have evidence on variability, they can present really any evidence on variability that's relevant to their device at the audit hearing, should they eventually fail an audit test. But I think, as Judge Wilkins pointed out earlier, there's really no evidence that these audit provisions have ever been a problem. Not in the previous rule, not for this rule. And if there is a concrete problem with variability and how it's affecting the audit provisions, that can be taken into account at a later time in a challenge to EPA's particular decision in an audit. But at this time, it's clear from the facts in the record that these audit provisions are reasonable. Now, Your Honors, I am happy to detail the flaws in the Hpva's study, but I don't know if that would be helpful to the court. Well,
let me ask, Judge Pillar, do you have any more questions?
Did EPA rely, I don't recall seeing this in the brief, but one of the things that's somewhat striking in the regulatory material is the fact that Washington State and Oregon and Europe and Canada have standards, I think I'm not wrong, in every case, as are more demanding than the EPA standard. And is that support that you're relying on here? If not, why not?
Your Honor, EPA did look to other standards that were in place when deciding what to set the standards at. But I think for the particular question that petitioners are raising here, whether variability is incorporated, that's hard to tell from just those numbers of the other standards because you don't know how many test runs were required, for example, if they were an average or what their allowance in their auditing provisions, if they had any were. So we're not specifically relying on that for this argument.
And let me ask you, why is an audit, a performance audit, needed at all? I think this is in Mr. Chung's briefing. What they would prefer is if you just looked at the product and made sure the product matched a prototype. Why isn't that enough? If the product, in a way it's implicit in the initial one representative device from a model line is enough for certification. And why isn't that enough over time to look at one representative device 3 years later and make sure that it's materially the same device?
Your Honor, of course, EPA is also looking at the devices themselves and making sure that they don't change over time. But there were other commenters, and particularly the states and local governments that are represented by the group of amici here, that were concerned about just the certification test process, that it's not being done by EPA, it's being done by the manufacturers. And they had concerns about, whether there was opportunity for bias there despite the conflict of interest provision, and whether there was need for more oversight. And EPA's had these audit provisions on the books since the very first standards for these wood heaters. So EPA acknowledged the concerns about the certification process and kept the audit provisions on the books.
All right, Judge Wilkins?
No, I don't have any other questions.
All right, then we'll hear from Mr. Chung for 2 minutes. Mr. Chung, you might start by giving Judge Wilkins and all of us the information he asked for.
Thank you, Judge Henderson. Regarding Judge Wilkins' question, so one of the main appendix sites to look to is the PowerPoint presentation that is at issue, which Judge Pillard rightly indicated should be viewed in context. That is a presentation that Hpva gave to, I believe it was EPA back in 2010, I believe. Don't quote me on the date there, because unfortunately the deck is undated. But that indicates that the Hpva is the member companies are the manufacturers, and they're concerned about not just achievability of the standard, but also the lack of precision in the test methods.
Give me a JA site, please.
202, I would say.
Does it identify any specific member company?
It does not call out companies by name, because in context at the time, Hpva's concern was the industry as a whole was staring down the barrel of this variability problem. And
it
the
does
same,
not claim them even as Hpva members.
I'd have to go back and check the surrounding slide deck to see if there are indications of, whether there's the express terms, these are members of Hpva. Now that is in the Hpva comment letter, but I think unfortunately the excerpts from the comments didn't make it into the JA. And so what you see from a very lengthy set of comments are the provisions specific to audit testing, where Hpva had already laid out in advance, like here's what the association is, here are what our members do. They make all three types of appliances.
Could you pull the entire comment letter? I mean, I guess we could get it, but if you could pull the entire comment letter and send us the full thing, that would be helpful.
Yes, I'd be happy to do that. So very briefly, in response to Ms. Bott's point, I think, again, it is important to place this case in context and look at the regulatory history. For decades, EPA's regulations reflected the recognition that variability is a problem. And that is why there were limits on the ability to audit. Those limits are no longer there. And there wasn't an explanation in the response to comments or the preamble as to why it was appropriate to lift those limitations. EPA, after the fact, is pointing to different studies in the record that provide that there is a dispute about the magnitude of variability, but there's never any data point that indicates that a test is going to come back identical every single time. And that's because that data simply does not exist. I think, it is incumbent on EPA, against the backdrop of a longstanding recognition that this is a problem, to explain to the court, how did it arrive at the claimed margins that it now says it built in? Where is the explanation in the record as to how they got to 1.0 gram per hour on the wood stove side, for example, or where they arrived at the random percentage on the central heater sides? Where is the explanation as to why that is a reasonable number, especially in light of their longstanding commitment to conduct a statistically sound analysis of variability? It seems like a thin leg to stand on to point to a manufacturer a letter from a manufacturer that came in after the close of the comment period, which is the Woodstock soapstone, by the way. It seems like a thin leg to stand on, given a longstanding promise to do a meaningful analysis of this issue, to say, oh, well, there's a manufacturer over here who claims that his data points are clustered around the same point. But how is that reasonable to rely on that manufacturer without an explanation as to why those data points are reliable, why that should be something that they can extrapolate across to the entire industry?
So, Mr. Chung, is the focus of your objection is the shift from same laboratory to any laboratory? That's what you're objecting to.
That is a major part of the objection, but it is also the fact that in the prior standards, there was a comprehensive approach to variability. And that was building a specific margin into the standard themselves, plus guardrails on the ability to audit. There are no longer
being
no interlab audits.
No interlab, but here they built in a margin. You disagree about the extent of it. And then the second thing would be the interlab. That guardrail has been removed. That's the key, no?
Correct, but I would you're right, but I would disagree. We don't agree that they built a margin in. We don't think they did that at all. The statements in the preamble don't bear that out. And again, how do you build a margin in when you have no data on the central heater side? So part of our point is the standards are set so low that if you accept our argument that they didn't actually build a margin in, it's arbitrary because all of the record evidence confirms that variability is real. So how can you finalize an audit provision that doesn't provide for adjustments to variability? Two final points on Ms. Bott's assertion about EPA being able to take any evidence whatsoever into account at a later date. Again, how does that square with the text of the rule that says that any exceedance results in revocation? There's no indication in the rule that EPA could excuse an exceedance on the ground of variability. So would they even be complying with their own regulation if in a future audit, they accepted evidence from a manufacturer explaining why their stove came back at, say, 2.2 instead of 2.0? Could they really excuse that by pointing to variability? That doesn't seem fair. The final point I will make is, and this goes to Judge Pillard's point about what a reasonable compliance program might look like. Coincidentally, in EPA's response to comments, they indicate that maybe a reasonable audit program and one that would be rarely invoked is one that would result in audits in the event of either a suspicion that the manufacturer is no longer making clones of the certified model, or a suspicion that somehow a lab might have fraudulently doctored the books during testing. Well, that's at JA 289. Coincidentally, that's also the sort of program that Hpva asked for, the sort of audit provision that Hpva believed would be reasonable. But that is very different from an audit provision that provides for no limitations on interlab audits, provides for no adjustments to the emission limit to account for variability. One that is based solely on the suspicion of fraudulent testing or a manufacturer no longer making clones of the original certified model is a very different looking audit provision than what we have here.
All right, if there are no more questions, then your case is submitted. Thank you.
Thank you.
This honorable court is now adjourned until Friday, January 29th at 9:30 a.m.